Hey guys, Andrew Haggerty, Century 21 Haggerty here. We're going over part 2 of the 1 to 4 family contract form. We already did part 1. This is going to be starting at paragraph 7, property condition, through the rest of the contract. So if you have any questions about the earlier section, go to our video on part 1. Property condition, access, inspection, utilities. Extremely important part of this contract. Seller shall permit buyer and buyer's agents access to the property at reasonable times. Buyer may have the property inspected by inspectors, selected by buyer and licensed by TREC, or otherwise permitted by law to make inspections, okay? What we're saying there is, can't be your friend, can't be your dad, can't be your uncle. It has to be a licensed inspector by the Texas Real Estate Commission or someone licensed in the business to do the work. Any hydrostatic testing must be separately authorized by seller in writing. Do not do hydrostatic testing. It is putting high pressure water through pipes. Pipes have cracks or clay or old, they will explode. Very dangerous to the home. Please do not do hydrostatic testing because it can destroy a seller's home. Seller's expense shall immediately cause existing utilities to be turned on and shall keep utilities on during the time this contract is in effect. You have agreed in writing to utilities on from the day of contract through the day of closing. We cannot turn the utilities off after inspections because appraisers may need them on to check utilities, to check to make sure all of the appliances work. Who knows? We have to stay on through the day of closing. I know it's frustrating for the seller. It has to be done. Please make sure utilities are kept on. Seller's disclosure notice. We want to talk about this. The seller's disclosure notice pursuant to subsection 5.008 of the Texas Property Code. Now, we have two main boxes. There are three, but there's two main ones. Buyer has received the notice or buyer has not received the notice. Now, if I'm going to represent the seller, I want to make sure we've always put buyer has received the notice, and we'll explain why right now. Number 2 is buyer has not received the notice within blank days of the effective date of this contract. Seller shall deliver the notice to buyer. If buyer does not receive the notice, buyer may terminate this contract at any time prior to closing, and earnest money will be refunded to the buyer. If seller delivers the notice, buyer may terminate this contract for any reason within 7 days after buyer receives the notice or prior to closing, whichever first occurs, and the earnest money will be refunded to buyer. What that means is, even if I don't have an option period and we have this situation, they can have, and that takes me 3 days to deliver the seller's disclosure. He has an additional 7 days to cancel it at any time for any reason. So it's basically a free option period. So if I'm representing the seller in this situation and I have the seller's disclosure, I'm going to cross out box 1 or 2 and put in mark box 1, have my client's initial, send it back with the seller's disclosure. I want to make sure they've had that. Box 3, the seller is not required to furnish the notice under Texas Property Code. There are certain instances where the seller does not have to fill out a seller's disclosure. They are acting as a trustee for a trust. They are a bank before foreclosure. There are certain reasons why they don't have to do it, but for the most part, they do. If you have any questions on that, please call me first. Acceptance of the property condition. As is means the present condition of the property with any and all defects and without warranty except for the warranties of title and the warranties in this contract. Buyer's agreement to accept the property as is under paragraph 7D1 or 2 does not preclude the buyer from inspecting property under paragraph 7A, from negotiating repairs or treatments in any subsequent amendment, or from terminating this contract during option period. Okay. Accepting this property as is does not mean I can't negotiate repairs later. So I strongly recommend you always mark box 1, buyer accepts the property as is. The problem with marking box 2 is if we're going to ask for something, now at the contract they agree to it, and then we get an inspection and we ask for more stuff. And then we get an appraisal and we ask for more stuff. And it just it turns it into a personal vendetta situation with the seller and the buyer, and it's just not healthy. We know we want these things already fixed. We're going to ask them when the inspector comes. On top of that, if you do mark box 2, you are not allowed to put any generic phrases such as subject to inspection, lender required repairs. You cannot write a blank check in this paragraph that would force the seller to fix certain things. It has to be very specific repairs. I want you to fix the window in the master bedroom. I know what you want done. We've agreed to it. I have an idea on price. It cannot be general phrases in there or you can get in serious trouble. Lender required repairs. Who's responsible? Nobody. Unless otherwise agreed in writing, neither party is obligated to pay for lender required repairs, which includes treatment for wood destroying insects. Parties don't agree to pay for the lender required repairs or treatments. This contract will terminate and earnest money will be refunded to buyer. Cost of lender required repairs and treatments exceeds 5% of the sales price. Buyer may terminate this contract and earnest money will be refunded to buyer. Okay, we don't have to. Just because it's a lender required repair doesn't mean I have to fix it as a seller. We have to agree to it, or But if we can't agree to it, the buyer gets his owner's money back. So that's something to understand. Completion of repairs and treatments, extremely important, guys. Can't have your friend, your uncle, or your dad, or your neighbor fix the repairs. Unless otherwise agreed in writing, seller shall complete all agreed repairs and treatments prior to closing. All permits must be obtained, and repairs and treatments must be performed by persons who are licensed to provide such repairs or treatments, or if no such license is required by law, are commercially engaged in the trade of providing such repairs and treatments. At buyer's election, any transferable warranties received by seller with respect to repairs and treatments will be transferred to buyer at buyer's expense. Seller fails to complete any agreed repairs and treatments prior to closing date. Buyer may exercise remedies under paragraph 15 or extend closing date up to 5 days if necessary for seller to complete repairs. They have to be repaired prior to closing. They have to be done by a professional. It can't be some guy showing up, sticking two things together with bubble gum and calling it a day. It has to be done well. You're selling your home to somebody else. You don't want to come back on you. So this becomes a huge fight all the time. Can I just have my uncle fix it? No, you can't just have your uncle fix it. It has to be done by a professional. Environmental matters. Buyer advised that the presence of wetlands, toxic substances, including asbestos and waste, or other environmental hazards, or the presence of threatened or endangered species to a habitat may affect buyers' use of the property. If buyers are concerned with these matters, we strongly recommend you get use an addendum promulgated by TREC or required by the parties to be used. We have to give this notice to a buyer. This is, in fact, giving that notice to you and protecting you as the seller. Paragraph H, residential service contracts. Extremely important, guys. Buyer may purchase a residential service contract from a residential service company licensed by TREC. If buyer purchases a residential service contract, seller shall reimburse buyer at closing for the cost of the residential service contract in an amount not to exceed blank dollars. Buyer shall review the residential service contract for scope of coverage, exclusions, and limitations. The purchase of a residential service contract is optional. Some of our coverage may be purchased from various companies authorized to do business in Texas. Strongly recommend a home warranty, guys. They're extremely important. They're very good for the house. They give that buyer an additional peace of mind in case something breaks. They won't come after the seller. Water heater breaks after 3 months. Instead of suing the seller, pay $75, $100, whatever the agreed amount is. It's covered. Paragraph 8, broker's fees. All obligations of the parties for payment of broker's fees are contained in a separate written agreement. We do this for a reason. Our interests are not above our client's interests. Our payment has nothing to do with this contract and will not have anything to do with this contract. Closing. The closing of the sale on or before the closing date or within 7 days after objections made under paragraph 6D have been cured or waived, whichever date is later. If either party fails to close by this closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. Okay. We'll get to that here in a little bit. At closing, seller shall execute a general warranty deed conveying the title to the property to buyer and showing no additional exceptions to those permitted in paragraph 6 and furnish tax statements or certificates showing no delinquent taxes on the property. Buyer shall pay the seller's price in good funds acceptable to the escrow agent. Seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, and other documents reasonably required for the closing. There will be no liens, assessments, or security interest against the property, which will not be satisfied out of the sales proceeds unless securing payment of any loans assumed by buyer and assumed loans will not be in default. If the property is subject to a residential lease, seller shall transfer security deposits as defined under subsection 92.102 of the property code. If any, to buyer. In such an event, buyer shall deliver to the tenant a signed statement acknowledge the buyer has acquired the property and is responsible for the return of the security deposit, specifying the exact dollar amount of the security deposit. That is extremely important. You need to make sure if you're buying this property, everybody's on the same page how much the security deposit is, the buyer, the seller, and the tenant, so there's no surprises, as well as what the rent is and a copy of any leases. You want to make sure if you get a $300 deposit and then 4 months later the tenant moves out and says, I gave you a $1,000 deposit, where is it? You're on the hook for $1,000. So you need to make sure we're all on the same page today. What is the deposit and do I have it so I can give it back? Because that deposit belongs to the tenant, not to the seller or the buyer. Possession, extremely important. Buyer's possession. Seller shall deliver to buyer's possession of the property in its present or required condition, ordinary wear and tear accepted, upon closing and funding, or according to the terms of a temporary residence lease form promulgated by TREC or other written lease required by the parties. Any possession by a buyer prior to closing or seller after closing which is not authorized by a written lease, will establish a tenancy and sufferance relationship between the parties. Important. Consult your insurance agent prior to change of ownership and possession because insurance coverage may be limited or terminated. The absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. So make sure if you're doing a temporary essential lease, the insurance company is aware and you are covered for those situations. Because if the buyer owns the home, the seller's in there as a tenant, and something goes wrong, you don't have landlord coverage or something to that effect, you may not be covered. So be very careful. Leases. After the effective date, seller may execute any lease, including but not limited to mineral leases, or convey any interest in the property. You cannot sign any leases after we've executed this contract. If the property is subject to any lease to which seller is a party, seller shall deliver to buyer copies of the lease and any moving condition form signed by a tenant within 7 days after the effective date of the contract. Special provisions. Do not write anything in special provisions. I can't be any more clear than this. Paragraph 11 is not to be used. There's a very important reason for this. One, you are not an attorney. You cannot write law. Two, TREC rules prohibit license holders from adding factual statements or business details for which a contract addendum, lease, or other form has been promulgated by TREC for mandatory use. You accidentally write something in here that TREC has created the promulgated form for, you have violated your Texas Real Estate Commission rules. That is not something you want to do. Do not write anything here. If something has to be written in here, get with me and get the approval. If you're just watching this video and I do not represent as a broker, talk to your broker. Okay, do not write anything in paragraph 11. Paragraph 12, settlement or other expenses. This is outlining who's paying what expenses. The following expenses must be paid at or prior to closing. Expenses payable by seller are. It's going to list all of the seller's normal expenses. Releasing of existing liens, including prepayment penalties, recording fees, releasing of the seller's loan, liability, tax statements, certificates, preparation of the deed, half of the escrow, and any other expenses. Paragraph 12AB, seller shall also pay an amount not to exceed blank dollars to be applied in the following order. Buyer's expenses, which buyers burdened from paying by BAA, and any other expenses that they have. So this is where you're going to put seller's concessions. I want you to pay $3,000, $4,000, $5,000 for its closing costs. You're going to put that in paragraph 12AB. Okay. The portion 2, 12AB 2 of this is expenses payable by a buyer. This is going to be a breakdown of all the buyer's expenses that could be on a contract. Appraisal fees, loan application fees, breaking down all of those different fees. If any expense exceeds an amount expressly stated in this contract for such expense to be paid by a party, that party may terminate this contract unless the other party agrees to pay such excess. Prorations, taxes for current year, interest, maintenance fees, assessments, dues, and rents will be credited through day of closing. Seller owns the home through the day of closing. So the seller's responsible for taxes through the day of closing. They'll be prorating on at that time. The tax proration may be calculated taking into consideration any charge and exemptions that may affect the current year's taxes. If taxes for the current year vary from the amount prorated at closing, parties shall adjust a proration when tax statements for the current year are available. If taxes are not paid at or prior to closing, buyers shall pay taxes for the current year. So you're going to get prorated your amount at closing, but responsible for the entire tax year at the end of the year. Casualty loss. If any part of the property is damaged or destroyed by fire or other casualty after the effective date of this contract, seller shall restore property to its previous condition as soon as reasonably possible. But in any event, by the closing date. If seller fails to do so due to factors beyond seller's control, buyer may terminate the contract and earnest money will be refunded to buyer. Extend the time for performance up to 15 days, and closing date will be extended as necessary, or accept the property's damaged condition as an assignment with an assignment of insurance proceeds. So that means in English, house burns down to a fire. I either wait for them to build the house back up, I terminate the contract, or I accept the property as is along with the insurance money so I can build it up to how I want it. Those are my options in a casualty loss situation. Default. If buyer fails to comply with the contract, buyer will be in default, and seller may enforce specific performance, seek such other relief as may be provided by law, or both, or terminate this contract and receive earnest money as liquidated damages, thereby releasing both parties from the contract. If I accept earnest money, I have accepted earnest money as liquidated damages, and I cannot sue the party afterwards. It's very important to understand that. If you accept the earnest money, you've accepted liquidated damages. Seller will be in default, and buyer may enforce specific performance, seek such other relief as may be provided by law, or both, or terminate this contract and receive the earnest money, thereby releasing both parties from the contract. Again, if you accept the earnest money, You've accepted liquidated damages, and the deal is over. You can't take earnest money and then sue them later. Again, I'm not an attorney. I cannot give legal advice, but that's what this contract states. Mediation. It's policy of the state of Texas to encourage resolution of disputes through alternate dispute resolution proceeds such as mediation. Any dispute between seller and buyer related to this contract, which is not resolved through informal discussion, will be submitted to a mutually acceptable mediation service or provider. Attorney's fees. A buyer, seller, listing broker, or other broker or escrow agent who prevails in any legal proceeding related to this contract is entitled to recover reasonable attorney's fees and all costs of such proceeding. Paragraph 18 is what happens with the title company is going to do with if there's any issues. Let me be very clear. This has to do with earnest money. They're not going to release earnest money until all parties have agreed what to do with earnest money. So I don't care what this paragraph says. Unless they have a signed form by all parties to release earnest money, they're not going to. You can ask for the demand, but they've been burned a lot. You have to have it done. Representations. All covenants, representations, and warranties in this contract survive closing. If any representation of seller in this contract is untrue on the closing date, seller will be in default unless expressly prohibited by a written agreement. Seller may continue to show the property and receive, negotiate, and accept backup offers. So we're agreeing in this contract. I can still show this property, and I can get backup offers. Federal tax requirements. If seller is a foreign person is defined by Internal Revenue Code and its regulations, or if seller fails to deliver an affidavit or a certificate of non-foreign status to buyer, that seller is not a foreign person, then buyer shall withhold from the sales proceed an amount sufficient to comply with applicable tax laws and deliver the same to the Internal Revenue Service together with appropriate tax forms. Internal Revenue Service regulations require filing written reports if currency in excess of specified amounts is received in this transaction. The buyer is responsible to withhold this money from the seller. So make sure in this situation, the title company is making sure that the seller is not a foreign person and what needs to happen so that the buyer is not on the hook later for a huge tax debt. Now, all notices from one party to the other must be in writing and are effective when mailed to, hand-delivered, or transmitted by fax or electronic transmission as follows. The buyer at blank, the seller at blank. I understand there's a fear about putting your client's information because then they have it, but if you put your information here, if you put your email address and you get the email, it is delivered. It is done. Even if it goes to spam, they prove you got it, you got it. So be very careful about putting your information there for the buyer's notices. Agreement of all parties. This contract contains the entire agreement of parties and cannot be changed except by written agreement. Addenda, which are a part of the contract, this is the most common addenda that are there. There are other addendums out there, and that is when you would hit the other and write them in. Third-party financing addendum, seller's addendum. Addendum for backup contract, seller's temporary residential lease, buyer's temporary residential lease. So these are the main addendums that can be there, but if it's one of the other ones, you would put it in the box and mark it there. Paragraph 23, extremely important paragraph, okay? For nominal consideration, the receipt of which is hereby acknowledged by seller and buyer's agreement to pay seller within 3 days after the effective date of this contract. Now, when we talked about earnest money, you had 3 business days. Okay, if it was a Friday, if it fell on a Saturday, Sunday, or legal holiday, then it carried over to the next Monday. Paragraph 23 does not have that stipulation in this contract. So if you have paragraph 23 in play, you have 3 days, period. If it's Thursday, you have Friday, Saturday, Sunday. I have until Sunday to deliver that option money to my client, to the other agent. If they do not receive it, then we'll go into that right now. Seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within blank days after the effective date of this contract option period. Notice on this paragraph must be given by 5 p.m. local time where the property is located. So if we're in El Paso, Texas, we're using Mountain Time. 5 p.m. Mountain Time is when our notices have to be delivered by. Notices under the paragraph must be given by stated as the option fee or if if no dollar amount is prescribed, this paragraph will not be part of the contract and buyer will not have the unrestricted right to terminate this contract. Buyer gives notice of termination within the time prescribed. The option fee will not be refunded. However, any earnest money will be refunded to buyer. The option fee will or will not be credited to the sales price at closing. Time is of the essence of this paragraph and strict compliance with the time for performance is required. Okay? If you do not deliver earnest money, paragraph 23 goes away. Only paragraph 23 goes away. So if I do not deliver earnest money within this 3-day period, I cannot cancel at any time for any reason and exercise my option period. But if I have a seller's disclosure time window, I still have that window I can use. So be very careful and make sure what you're doing. We are disclosing very carefully. Consult an attorney before signing. Truck rules prohibit real estate license holders from giving legal advice. Read this contract carefully. We're telling you to read it. If you have an attorney, we're going to put that information there. If not, so be it. Executed the blank day of blank to the 20 blank. The effective date. We do not mark this effective date until all parties have agreed to every single issue, every single change. This starts the clock for everything. This is the day zero. We now have a contract. Buyer signatures, seller signatures. Page 9. Okay. Page 9 of the contract is the separate written agreement between brokers. Okay. Now, this is important when you're filling this out. Listing broker information, their license number. Seller buyer is an intermediary or seller's agent only. Listing associates information, their license number, their email address, their phone number. The licensed supervisor of listing agent, their license number. This will be the broker if you're part of a team, the team leader in that situation. The listing broker's address, office, and information there. Now, if it's an intermediary situation, the selling associates information will go on the bottom section. Now, if it is not intermediary, you're going to use other broker. So this is a listing by one company or our listing and another company sells it. We're going to use both sides. If not, if it's an in-house deal, both of them are Century 21 Hagerty agents, you are only going to use the right-hand side or left-hand side, depending on how you read it, of this form, okay? Other broker firm, their license number, the firm's license number, buyer only as buyer's agent, or seller as listing broker sub-agent. How are you representing them? Associate's name and license number, email address, phone number, licensed associate's supervisor's name, license number, all of that information. Listing broker has agreed to pay other broker blank of the total sales price when listing broker's fee is received. You don't get to change what is MLS. Okay, this is a very important rule for the multiple listing service. If someone is offering a 2% commission and you show that house, you've accepted a 2% commission. You cannot go in here and write 3% and say, haha, fooled you. It does not count. It does not apply. As soon as you have shown that house, you've accepted a 2% commission. Now, if you have a buyer's representation agreement or something that says you have to get a 3%, you can contact that agent and say, as long as the buyer's on the same page, say, my buyer has instructed me only to show them homes paying at 3% because they do not want to pay the difference. Are you willing to pay 3%? If they say yes, you have it in writing. Now you can put it there. But be very careful about putting that in. Page 10 is all about receipts, and this is extremely important now. We're going to want these. You're going to get the option fee receipt from the other agent. When you drop it off, you're going to make sure you get receipt, prove it was done. You're going to get a contract receipt from the title company when you drop off the contract to the title company. Along with the contract, you're going to drop off earnest money. You're going to get an earnest money receipt. If you have additional earnest money receipt or additional earnest money, you will receipt that in as well. Make sure it's part of the contract. Get that in there. Get it in there fast. Get it in there done. This is the second part of the contract, guys. I know it's a long video. I know it's a lot to go over, but extremely important. I hope this was helpful, and we'll have more videos coming out. Appreciate it, guys.